Tell Wes to come here. Wes.
Johnson, we're about ready to get on the record, so we're going to pretend like we're in court here in just a minute, all right?
Yes, sir.
All right, thank you. Welcome to the 186th District Court. Court is in session. This is State of Texas versus Larry Wayne Johnson. We're here today for sentencing. It's cause numbers 2019 CR 3596 and 2019 CR 7543. And we are conducting this hearing via video conference using the Zoom application. We are also using YouTube to live stream the proceedings to keep the hearing public. The time now is 10:59 a.m. on the 28th day of July 2021. These proceedings are official, they're on the record, and they're being reported by the official court reporter. Counsel and all present are instructed to act as though you're in court, and all are instructed not to record the proceedings. And if I could have the attorneys make appearances, starting with the state of Texas, please.
Travis Banks of the state of Texas.
Gary Chirac were the defendant.
And sir, you're the same Larry Wayne Johnson, who on June 16th of 2021 pleaded no contest. And then the first case I called was just a count one. And then to the second case, I think it was just a one count indictment. And that was on the evading case there. Are you the same person, sir?
Yes, sir.
And Mr. Chirac, have you had an opportunity to review the pre-sentence investigation report and the TAP evaluation?
I have, Your Honor.
In both these cases, the plea bargains are caps. The first one for the drug case is a cap of 12, and the state's opposed to any application for community supervision or deferred adjudication. In the second case, it's a cap of 10 years, and again, states opposed to any applications for community supervision or deferred adjudication. With that being the case, state, you may proceed.
Your Honor, just wanted to draw the court's attention to a couple things. First off, on the facts of the case or the cases, the defendant was found in the earlier case with 27 grams of just raw meth and another over 70 grams of meth-based ecstasy pills. It was about 349 ecstasy pills that were found on the defendant. He was pulled over for having a headlight out, and the foregoing evidence was found in his vehicle in the front seat. In a later case, the defendant was stopped. The officers got his ID and information, and one of the officers actually asked him about this previous case, and then after the officer went back to his car, the defendant left the scene in his vehicle. Now there was the defendant does have some criminal history, and I'll refer to that for a moment. Flip over to that document. In 1994, he was convicted of possession of PG1, 1 gram to 4 grams. 2005, another conviction, this time for assault causing bodily injury on a family member. He's got 3 convictions for PG1 less than a gram, so there's some drug history there. And the TAP evaluation did also note that he has a history of drug abuse and addiction that maybe probably explaining these drug arrests. So that's kind of the summary of it, Judge, and the state is, the court is aware of the state's recommendations in this case.
All right, thank you, sir. Mr. Chirac, you may proceed.
Your Honor, I would call the court's attention to the PSI and Mr. Johnson's admission of guilt. Mr. Johnson has admitted that he has a drug problem, and he is amenable to treatment for that problem. Basically, Judge, he was a delivery boy in this. He stated that he was basically driving the stuff to drop it off to somebody else. I don't believe he's a major dealer in this situation. I think the situation was, hey, you drop the stuff off and I'll give you a couple of hits of coke, which was his drug of choice, or meth, or whatever he wanted at that time. Judge, we would ask the court consider the fact that because of his drug addiction, that perhaps rehabilitation and rehab would be a better suitable punishment for him than imprisonment.
All right, thank you, Mr. Churak. All right, in each case, sir, I find that your plea was freely, intelligently, and voluntarily made. There was sufficient evidence to support the plea and that you're mentally competent to enter into such pleas, and I find you guilty in each case. Mr. Churak, is there any legal reason as to why your client cannot be sentenced today?
There is not, Your Honor.
No legal reason. According to agreement states, sir, in each case, I'll sentence you to 10 years in the Texas Department of Criminal Justice, and I'll give you credit for time served. There's a $1,500 fine in each case, and each case will run concurrent with each other. Sir, in each case, this is a plea bargain case. I followed the plea bargain, so you do not have the court's permission to appeal. You do not have the right to appeal. Also noting you waived your appeal in the plea bargain agreements. I'm making a certification of this for the record in each case. I'll provide a copy of the certification to your attorney to provide to you. Sir, there was a tremendous amount of drugs in the car.
Yes, sir.
Hey, on Rios,
Hold on,
Are
Mr.
we-
Burks. There we go. All right, just for the record, we had somebody's microphone got turned on. There's an incredible amount of drugs in the car. You made bond and then you got pulled over and you evaded arrest after that as well, too. You're trying to say that you really didn't know what was going on. I think you knew exactly what was going on. And so I think you should be punished. I took into account your age as well. But I mean, I just have to believe that this is a proper amount of punishment for that type of crime and punishment, and especially considering that you put everyone in danger by evading arrest as well on your second case that we had. It doesn't give me pleasure sending anyone to prison. I'll note that these are not 3G offenses. You'll be eligible for parole probably sooner than later on these cases. But the hope is with institutional supervision, you won't conduct yourself in this manner anymore. There's one thing I need to address on this certification of appeal on 2019 CR 3596. We did have a motion to suppress, and we have checked the block that matters were raised by motion, and these were not withdrawn or waived. But I think we did waive them in the plea bargain, Mr. Churak.
I don't recall, Judge, but it's possible. I think I was part of the plea bargain, if I'm not.
Yeah, I was going to say. So I'm going to, just for the record, I'm going to scribble that out, put my initials on each side of it. But I'm making a certification that's a plea bargain case, and there's no right to appeal based on that. Plus, that the right to appeal was waived in the matter on the plea bargain. All right, sir. Good luck to you. That concludes.
Judge, Judge, one more thing. I don't know if you told him that he would get credit for full-time served.
Oh, yes. So you'll have credit for time served in each case, and I'm running them concurrent as well, too. All right. Again, good luck to you, sir. This matter is now concluded. We are in recess. I'm turning off YouTube Live.
Thank you, Judge. Be excused.